These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
So, what I figured I would do, since we really don't have, you saw how long it took to go through that one process. So rather than try to fit an entire process and not be able to adequately or sufficiently explain it, like that, in the time, what I'm going to do is show you the template for handling anything that, let's say no matter what process you're working on, whether it's private contract dispute, secured debt, civil court, criminal court, or unsecured debt, from time to time, there may be something for you to handle, like I'm handling this unsecured debt, let's say a credit card, and before I even complete my process, I get another statement in the mail. But I've already submitted a statement showing a zero balance. So what do? Well, you could do an entirely new process, A for Ving it and all that, but in reality, do we want to do an entire new process on it, or do we want to just handle it in one step? Okay, so, and same with, let's say I'm dealing with a mortgage, and I'm dealing with the CFO, and I get a correspondence from legal counsel at the bank telling me, oh, well, this isn't valid payment, and blah, 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 right? So this little miracle document, series of documents, ever since I put these out, gosh, was it last year? A year and a half ago? I don't know. When I started showing people how to use this document and to get their remedy, it really started throwing a wrench in a lot of the public entities' ability to get you into an agreement and default you and thereby execute their remedy. Because this is simply saying, in a way that doesn't create controversy or argument, that, hey, I'll accept what you claim. I'll accept granting it to you, what it is you want me to give you or grant to you, upon these conditions. If you fail to meet these conditions, well, then here's what the contract's going to be. But something that's missing is most people take this, just put their name on it, and don't sufficiently address the points that need to be addressed in their particular issue. Like, for instance, you could use this one-step process on a civil case. And after acquiring your record for it, submit it in on the private side showing we've got agreement. However, let's say it's a civil case and they're bringing up several points. You must address each of their points in your conditional acceptance. Because if you don't address their points, they can actually turn it around on you and say, well, he never addressed or rebutted our presumptions. And by not addressing their presumptions, you're in agreement with their presumptions. Okay? So this is actually a good example because this one is based on the civil suit that I dealt with. This was actually part of my step one. Now, this one's got a very unique structure to it because I was conditionally accepting and tendering a payment, which I had to be very careful about. Because I'm tendering the payment, but tendering the payment in such a way that I'm making sure that they're clear that there is no agreement to their points, right? I'm not, because a lot of times you're making a payment, and if what you're doing is just tendering the payment, well, then you're in agreement. There is an account out of whack, and I agree with all your points. I'm saying in this process, there may be an account out of whack, and if there is, well, here's an instrument for you to set off any and all account liabilities. However, all these other points you guys are making, which have nothing to do with an outstanding balance, I conditionally accept. Okay? So, again, what's the first thing we need to address in any process, Jack? The parties, right? So here we have a principal. Goes by the name of Brandon Alexander Adams. And we have the respondents. Remember, I identify, I got a complaint. And there were all kinds of names on this complaint. So I wanted to make sure I address everyone. Because any name on that instrument signifies some interest. So I want to make sure that anyone who may have an interest is addressed. Now, because there was one particular party who was executing the document, I sent the notice to him for all the other parties. So I name all the parties here in respondents. But it's care of that guy, the main guy, the executioner. Or the executor, I guess. Regarding, and I make sure I make mention of
Did you send
the account.
Did you send copies to each of those? Or did you
Actually,
just
not
send
on
one copy?
When I got to step 2 is when I started addressing them individually because this particular process involved a negotiable instrument. And I'm not going to send out multiple negotiable instruments. So I sent in one negotiable instrument with one process. This is like my case. But when I got to step 2, I sent them out individually to all the parties at their individual addresses, letting them know, hey, you know that guy who's your agent received an instrument and an affidavit, and he's failed to respond. Here's your opportunity in case, as the agent for you, he didn't forward this to you. Because if you notice, each party is named but is sent in care of the one party. Okay? So, starts off, dear gentlemen, I am in receipt of your 3 presentments, complaint for permanent injunction and other relief, hereinafter complaint, dated March 15th, 2010. The originals, with the original banker's acceptance endorsements, are enclosed herewith. As the secured party creditor and the holder of the paramount security interest in any and all real and personal property and the proceeds therefrom registered to, associated with, in the possession of or under the management of Alexander H. Adams, Brandon A. Adams, and Garrett R. Adams, your alleged claims and or requests prejudice my rights, titles, and interests in regards to said property as the executive trustee for the private trust to which said rights, titles, and interests have been pledged. In order for me to provide you with a remedy, a bona fide claim and verified claim must be presented. Therefore, I am conditionally accepting your offer for injunctive and other relief upon proof of claim that, remember, you must address all their points. Now, this gets interesting. One, that, just to make it easy, defendants have engaged in any of the conduct you have alleged in the complaint. Two, the defendants have caused any harm, loss, or injury as you have alleged in the complaint. Three, there is a defect in the instrument tender and enclosed herewith, private bond promissory note number, hereinafter instrument. 4, the instrument is not sufficient to set off, settle, and discharge any and all outstanding obligations, duties, and or liabilities alleged and attributed to defendants. You have 10 days from receipt of this constructive notice of conditional acceptance and the enclosed affidavit of specific negative averment, hereinafter affidavit, to respond on a point-by-point basis via sworn affidavit under your full commercial liability, signing under penalty of perjury that the facts contained therein are true, correct, complete, and not misleading. Mere declarations are an insufficient response. If an extension of time is needed to properly answer, please request it in writing. Failure to respond will be deemed agreement with the facts stated in the enclosed affidavit and an inability to prove your claim. So you'll notice in the conditional acceptance, because I like to keep it nice, sweet, and compact, I just blanket statement their complaint with the one item right there that the defendants have engaged in any of the conduct you have alleged and that the defendants have caused any harm, loss, or injury as you have alleged. Now, in the affidavit, I'm going to actually address point by point every single thing they've alleged. And they sent me a 22-page complaint.
You know, I was thinking, Brandon, we have a conditional acceptance. Do we really fully understand the value and the importance of the term conditional acceptance?
Well, I do.
Yes, I know you do. I've heard that a conditional acceptance is always a counteroffer, and I heard that a conditional acceptance being a counteroffer, that counteroffer is defined in Black's Fifth and many of the other editions as a statement by the offeree which has the legal effect of rejecting the offer and proposing a new offer. And at first I didn't really give that a lot of thought, but you know, when you give it deep thought and a little bit of study, ladies and gentlemen, it's really important to understand it has the legal effect of rejecting the offer. So when he puts a conditional acceptance together, or you do, it is an extremely powerful tool and has legal effect of rejecting the offer. Got to give that a lot of thought, and because you're going to be involved in conditional acceptances as you attempt to in practical application maintain your contract. And unless you have a full understanding, complete understanding of that term, conditional acceptance, counteroffer, and what it means, it's really going to affect your ability to understand deep-seated in your heart why you get remedy.
So, like he said, it's a counteroffer. We're canceling the offer. The offer was their complaint for injunctive relief, right? So I'm pushing that aside. That's off the table now. This is now the contract. And I'm doing it in a way that I'm not alleging anything. I'm not charging my brother. I'm not accusing. I'm not creating controversy. I'm not being an adversary. I'm saying, hey, you say you have a claim. Your claim prejudices my rights, so in order for me to effect a remedy for you, I'm literally offering that. Hey, I'm going to step up and give you your remedy. All I need is this. So I also go in this next paragraph, I'm basically making sure that they don't misconstrue why the instrument is enclosed with this. The instrument is being tendered in good faith for the set-off and or discharge of any and all alleged obligations, duties, or liabilities attributed to the defendants, thereby protecting and preserving all my rights, titles, interest, and remedies regarding any and all property registered to, associated with, in the possession of, or under the management of the defendants. Take notice of the pre-offset notice for balance book adjustment enclosed herewith. It may contain significant information regarding your duties as the holder in due course and your obligation to exercise ordinary care with regards to the instrument.
Sounds like it's part of your counteroffer.
It is indeed part of my counteroffer.
And what might, if I don't say anything about it, I guess it's going to be binding on me, isn't it?
It is indeed, if you don't respond.
And is it when I get that, or when is it received?
The moment it drops into the mail.
You mean I don't have to get it to be received the minute it's dropped in the mail?
No, and interestingly enough, you'll see when I show you this actual process, when we get into the court stuff, you'll see that when I got to step 2, one of the guys wouldn't go pick it up from the mail. And yet, my process was moving forward, whether or not he went and got it from the mail or not.
Why again?
Because it's delivered or executed, it's received at the moment it is dropped into the mail.
Go to the mailbox rule in your contract books and go to the UCC and look at definition of received. It sounds strange. You send it, you put it in what's termed a proper delivery service like the U.S. mail. It's right then and there. It is received, ladies and gentlemen. They are deemed adjudged to have gotten it into their possession. Now that's why you like to have a little bit of testimony in the form of a certified mailer, etc. Because when it goes in there, somebody says they did receive it. You got a witness says they got it. You didn't send it, they received it. Powerful tool. Jack?
Indeed.
Yeah, I wanted to make notice of the fact that when you're doing that, most patriots don't understand UCC 1-308. You know, 1308 now is the equivalent of what 1-207 used to be. And in 1207, you're claiming to reserve all of your rights. But under the definition of rights in the UCC under 1201, subpart 34, there is no rights. A right is now defined to be a remedy. And then when you go to 1-201, subpart 32, I believe, it defines what a remedy is. And a remedy is any administrative process, including a self-help process. And these remedies then are all actions, and you can look up actions under 1-201 subpart 1, and you'll find that actions really are things like set-offs or recoupments. There are no such actions like common law actions recognized in commerce. But the important part of 1-308, the patriots always look at that part that says that you can reserve your rights. But in that language, it says that you can reserve your rights if you either promise performance or are doing performance according to the tenor of the opposite party that you're dealing with. So when you're constructing this conditional acceptance for value, you are raising issues for them to respond. But since they allege they've got an account which needs to be set off, settled, and closed, when you say that this instrument is being tendered here, what you're really doing is promising performance according to what they want you to do. And the only conditions on that performance then being completed is their response to your conditional acceptance. So you are indeed, quote, reserving all your rights, unquote, under 1308 because you're tendering a prospective instrument here to set off, settle, and close the accounts.
And typically when patriots sign and put UCC 1-308, they're actually refusing to perform. Which is funny because really they've just negated the statement of UCC 1-308 because you're only reserving your remedies and rights when there's a promise to perform.
Now, Jack and Brandon are giving all these numbers and quotes and subprin 1 and this and that. And don't let it confuse you. They're speaking, he's going to tell you, you're not in the master's class, but you have a UCC book that's got nine articles, 9 sections, and he's quoting from UCC 1-201, and he gives these definitions and subprint 32 and 34 and number 1. Those are merely the numerical numbering of the definitions of certain words. So it gets real nice, it gets simple. You go to UCC, first article 1-201, and you're going to find a whole bunch of definitions that apply under certain terms and conditions throughout that book, and sometimes they change within the other articles. But if you get a little familiar with it, all this kind of sophisticated sounding stuff will distill down into something that makes good sense to you.
So I can sign my name.
What's that?
I've been signing my name, Melanie Herrera 1-308. So I shouldn't be doing that. I've been doing that.
Have you been performing?
Mel is like a different type of person. She's the one.
She's a secure party
She
creditor.
usually comes back and says, I don't agree to perform, but nevertheless, I want 1-308. So she's one of the old timers.
Joyce told us to do that.
Don't listen to Joyce.
Because so-and-so. How many of you are going to walk out of here? Well, Brandon, Gordon, and Jack told me to do that. Figures Gordon will. Okay, executed in Orange County, California Republic, this 19th day of the 3rd month in the year of our Lord, 2010. Witness my hand and seal. Down below that, you'll see, please direct responses to third-party witness, and it's got my notary's information there. I've got some enclosures here, an affidavit of specific negative averment, a pre-offset notice for balance book adjustment, a private registered bonded promissory note, 3 complaints for permanent injunction and other relief, all A for V, both sides. That was a pain in the butt. Just doing that, and then having to have a record of that. So I had to scan 63 pages, front and back. Yeah, it does suck. Took me a while. An IRS 1040V and a notary certificate of service. Notice, this document is not intended to threaten, harass, hinder, or obstruct any lawful operations. It is for the purpose of attaining lawful remedy, and as is provided by law. What law? The contract.
Brandon, before you go any further, if I can squeeze in a question here, will you sign your name? I don't know if I missed it, but sometimes you have by, and other times you don't.
Yeah, I
Is there a reason for it?
Yeah, because when you're saying by, you're signing in the capacity of some other thing. Not to say that Brandon Alexander Adams, which is a private trust, but in commerce, a private trust is a natural person. So I'm not signing in a representative capacity. I'm the executive trustee. So I can sign without putting by. However, if I'm going to sign for the bank as the attorney in fact, I will definitely put by. If I'm going to sign as the debtor, if I'm going to sign for the debtor as an attorney in fact, or as an authorized representative or something like that, I'm going to have by.
And
right.
And does your signature actually change, or use the same?
No, my signature is handwritten, legible, all my whole name.
When you do it either way, with by or without by, it's the same?
It's the same.
Okay. And earlier you were talking about once you drop it in the mail, it's delivered. What if somebody refuses it, or they cannot pick it up?
It's still received.
Okay, so if they refuse it and it comes back, because I don't know how it works with registered mail, but with certified mail, if nobody picks it up for so many weeks, they send it back anyways.
Right.
Or if they
you'll
refuse
see,
it, it's going to be
like I said, when you see step 2 of my process, it starts, because I'm bringing all the parties together in my process, right? So I'm going to say the carrier, which I defined earlier as the USPS, right? The carrier attempted delivery on such and such a date. The carrier left notice on such and such a date that you had this package, right? On such and such a date, the carrier left another notice. The guy was like just refusing to go pick it up.
Now remember,
And because it was registered, the post office just kept leaving notices. Hey, you got something.
remember this: when you get back a refused package, do not open it. It's part of your permanent record. The judge and everybody else got copies of what's in there, and they need to see that sealed record of refusal. Do not open that returned record because it's going to go to the judge as the original. There's your evidence. Refused and still sealed by the post office.
And Brandon, didn't they do that after they had already received your first presentment?
No, this is the first presentment.
And they didn't open the first one? I thought it was...
No, they finally did.
Okay.
They finally did go pick it up. So it never actually came back.
But Brandon, if it did come back and you had to do your second, third step or what have you, would you continue to send it?
I would just continue.
Even
I
though
would
we're
just
refusing
continue.
it?
But
Okay.
you would see that my list of facts, as they are stated in the notice of fault, would say, like I said, the carrier attempted delivery, carrier left notice, carrier left another notice, carrier left yet another notice. The carrier returned it to the principal, and then I would have in there a fact for them to rebut that the respondent's failure to take heed and notice to the notices left by the carrier and pick up constitutes acceptance. And now what are they going to do? Say that, well, we didn't pick... I'll tell you this. IRS sends you something certified mail, and you know it's from the IRS, and you don't go get it. Do they get a default on you? Hell yeah, they do. They don't care whether you pick it up or not. Yeah, even without certified. Like I said, Winston, you can just drop it in the mail with 32-cent stamp. I don't care if you get it. I don't care if it ever arrives.
Remember, when you're also, if you need, to testify this, you go on USPS track and confirm on the computer and get a printout, and it will tell you tried to deliver at this date, left another
that's actually
notice.
where I got. That's where I got all the information that went into my notice of fault. That's how I know the dates that the notices were left and everything was going on USPS.
Did you not also attach the USPS track and confirm evidence as to that from the
No,
computer?
I didn't need to.
All right.
And
Yeah.
when I spoke with the Treasury agents, I asked them, when I was asking them about their process, I said, so you guys don't need to do a notice of fault or a notice of default or anything like that. The second they don't respond, that's default and you send out your bills, right? Yep. That was it. They don't do notice of fault. I mean, the due diligence that Brandon's showing you is above and beyond. I mean, realistically, if they didn't respond to your first presentment, they are in default. They agreed. But Brandon does a lot of due diligence, which is good. Shows the judge that you were trying to be a creditor and doing what you can. But the fact of the matter is, that's just overkill.
Yeah, I'm giving them opportunity. I'm not trying to injure or hurt anyone. And who knows? Maybe they got it, they set it aside and forgot about it. Maybe it slipped. Maybe he was carrying it home because he was real anxious to read it. Right? Got out of his car at the ATM to get some cash before he went home, and somebody ran by his car and plucked it out the back seat. I don't know. But that's why when I got to step 2, I made sure that all the agents involved got notice of the dishonor. Okay? So here we go, moving on. This is what's called a pre-offset notice for balance book adjustment. You can get this from Tim Turner's documents. This goes along with my instrument. It's basically a set of instructions of how to handle the instrument. Okay, now this is muy importante. This is my affidavit of specific negative averment. The undersigned affiant, Brandon Alexander Adams, hereinafter affiant, does solemnly affirm, declare, and state as follows. Affiant is competent to state the matter set forth herein. Affiant has knowledge of the facts stated herein. All the facts herein are true, correct, complete, admissible as evidence, and if called upon as a witness, affiant will testify to their veracity. What is the important... Now, this actually goes back to maxims of law. What is the significance and why is it so powerful to make statements in negative averment? Close. And I'll break it down easily. The maximum. Do you know the maximum of law, Gordon?
No. I think I know which one you might be talking.
Right. Right. If you state positively, the burden of proof is on him who states positively. That's a maxim. If I say, this isn't my glass, well, now you've made the positive statement, right? Or that's his car. Okay. Well, now you've made the positive statement. So it's not on him to prove it's not his car. It's on you to prove that it's his car. He did it, not me. Okay. Prove he did it.
There's a couple of things else going on in the background. There's a maxim, he that avers must prove.
Right.
But the other side of that is if it is a negative, you can never prove a negative. So if you aver a negative, it's not up to you to prove it. The other issue is in that Civil Rules of Procedure, Civil Rule 8, I believe it is, that suggests that in a pleading, the contents of a pleading can have an assumption or a presumption. And under the rules of pleading, if the other party sees an assumption or presumption in a pleading and does not specifically aver by negative averment that the assumption and presumption in the pleading stands as a stipulation and cannot be attacked in any of the trial. So they tell you flat out in Civil Rule 8 that if there is an assumption or presumption in the other party's pleading, the only way to raise the issue is by, at the first possible response, a negative averment, which has the effect of denying the assumption, requiring the party that set forth the assumption to come forth and prove it.
You hear the power in that? Now, let's just take a look at it. Remember how maxims of law come about, right? What is a maxim? A self-evident truth. How is it a self-evident truth? That if stated negatively, needs no proof, but if stated if stated positively, must be accompanied by proof.
In one sense, in its simplest form, when you state a fact, you become your brother's accuser, and so you violated God's law.
But that's getting into morals and ethics. Let's look at the logical side of this. Yeah, it's from the logical point, how can I prove a negative? I'm saying there is no evidence of this, and I believe none exists. Well, how can you prove there's none? How can you prove there's a no of something? You know? I'm just saying there's no evidence of it, and I'm not aware of any evidence being out there of this. Yeah, but if you're saying there is proof of it, well, then bring it. But I'm not unaware of any evidence or proof of this. And I can't prove by taking the position that there is none, and I'm not aware of any. So, getting into our negative averments, plain statement of facts, starting with number 4. There is no evidence that Party 1 has prepared and filed with the IRS false and frivolous federal income tax returns and or amended tax returns or other fraudulent tax-related documents on behalf of other persons, and the affiant believes that no such evidence exists. Now, this goes on to address every single point in their 21 pages, specifically because they had count one or allegation one or whatever, however they titled each one, and they go on and on and on. They first are accusing this guy of that, they're accusing this guy of that, they're accusing that guy of that, and they're just boom, 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 accusing all these people of all these things. So I, just like Jack said, rules of pleading. If I don't specifically negatively aver each point, then I am agreeing that that point is so.
You know, we're using the word evidence all over in this. What is evidence? And that's an important word because you all think you know what evidence is, but you need to have a thorough understanding of these words. Webster's has a real nice definition. That which tends to prove or disprove any matter in question or to influence the belief respecting it. And when you start replacing like law with the word contract, evidence with that which tends to prove or disprove any matter in question or to influence the belief respecting it, all of this starts to take on some real meaning for you, and your education is going to go so quickly. You're going to just speed right up and get into what he's doing. So bear that in mind. Please look up a lot of these words.
So I'll go over a couple more of these so you can see how each point is addressed.
Before you do that, let me make out a point. Remember how we've been suggesting that in the court, in their court, that the witness is in a witness box and the facts make absolutely no reference to anything they're doing in their court. Notice what Brandon is doing here is he is rebutting all the facts in a pleading. But what jurisdiction is this letter going out in? Private. It's in the Republic. Is the truth relevant in the Republic? Yes. And if there's affidavits here in the land, law of the land, or in the Republic, are affidavit of truth, something that is superior in commerce when it's carried on in the Republic? Yes. But this same document would be meaningless if it's down in the public sector.
You know, Jack just talked to you about the importance of an affidavit in the land, in the Republic. And this brings into your rules of commerce. And an affidavit is mentioned in 4 of those 10 rules. In truth, you've got, let's see, what do they have it? In commerce, truth is expressed in the form of an affidavit. And it goes on to say an unrebutted affidavit stands as truth in commerce. And then it goes on to say an unrebutted affidavit becomes a judgment in commerce. That's the importance of the power of what he's talking about in the Republic.
So, and actually when the structure of their complaint, they would take and combine the parties and accuse multiple parties of one thing. However, when I addressed it, I separated the parties and made sure that I negatively averred that this party didn't do that. This party, there is no evidence that this party did it, this party did it, or this party did it. And I did it in separate points. So where they combined them and said, well, all 3 of these guys are guilty of this, or they allege that all 3 of these guys are guilty of this, I go in and I address each party on each point. So we'll jump down here. There is no evidence that defendant 1 has engaged in fraudulent or deceptive conduct which substantially interferes with the proper administration of internal revenue laws, and defiant believes that no such evidence exists.
Brandon, are you just merely, as a point of interest for all of us, are you just merely taking the language right out of their complaint?
I'm taking it right out of their complaint.
So you're just parroting back, reflecting back to them.
By negative averment, yes.
Beautiful.
Yes, because right here you can tell, because you guys know I don't use code, right? But they were accusing these parties of violating code. So I said, oh, well, there is no evidence that defendant 1 has prepared and filed federal tax returns and or amended tax returns that understate any person's tax liabilities as a result of unreasonable and frivolous claims, and thus has engaged in conduct subject to penalty under 26 U.S.C. Section 6694. And if I believes that no such evidence exists. Addressing every single point. There is no evidence that Defendant 3 has prepared and filed federal tax returns and or amended tax returns that understates any person's tax liabilities as a result of willful attempts to understate said tax liabilities and or reckless and or intentional disregard of internal revenue laws and regulations, and thus have engaged in conduct subject to penalty under 26 U.S.C. 6694. And if I believes no such evidence exists.
I see that you have gone beyond your 1.5 pages. Would that be due to there are 4 pages of requisite
the only reason it's
required?
not nice and neat is because I needed to rebut every single point.
So we need to take critical examination of what we're doing and not try to keep it to 1.5. But if it calls for 4 because of something like this, we've got to open our mind to that. A little bit of critical thinking, right?
See how it gets up to point 53.
Now, while he's doing this, notice what the result has to be. Did the government on the other side or the accuser have to do any super due diligence to put down his unsupported allegations? No. But now that there's going to be a timely response, and it's going to be supported by an affidavit, what is going to happen to the unsupported allegations on the other side in regard to, can they continue their process? Can they, in good faith, go before a grand jury and get an indictment? No, not unless they rebut this with an affidavit or other evidence, because didn't we tell you that in Admiralty Maritime, once there is a charge, you're presumed guilty unless you prove yourself innocent? What is this affidavit of negative averment doing? Rebutting the assumption that there's guilt here. So you've proved yourself innocent as far as the record that stands. Their charges to which there's no evidence and no affidavit versus this response under oath and affidavit. So the way the record looks, both from the public and the private, they cannot in good faith go forward with a criminal prosecution in the public or in the private unless they get some evidence to rebut this.
You know, Jack said a very good thing, although he might have missed one small point. He said he's proved. No, what Brandon has done is termed disproved, because you can't prove anything. But that's what Jack means. Is in one sense, Brandon has absolutely proved his innocence via a counteroffer, which puts the onus probandi burden of proving on them, because none of us can prove anything. And that term is rebutting the presumption, or refuted, or confuted, or in a sense, simply disproved it. Kind of an interesting word. Go look that up.
You can't prove anything, but what is Brandon doing? It's all contract, offer, and acceptance. If the charging instrument or accusatory instrument is out there and you don't respond to it timely, you've consented. So they don't have to prove anything. They've got your consent. What Brandon is doing is a counter offer. So now they've got their time, 30 days, to come back. And if they don't respond, they have now consented that basically this response proves an innocence. Even though you cannot prove anything, you've got an agreement of the parties by the record that there is an innocence. And so they cannot proceed by agreement.
Brandon, what was I going to say? I forgot what I was going to say.
Okay. Now, what I'll do is I'm going to read you all these last 3 points, because the last 2 do not directly involve their allegations, but are bringing in the facts that I need in regards to the instrument being tendered. Okay? So right before that I have, there is no evidence that defendant 2 has engaged in, promoted, assisted, aided, and or prepared any fraudulent, frivolous, or fabricated federal tax returns, amended federal tax returns, and or information returns, and the affiant believes that no such evidence exists. Number 52, there is no evidence of a defect in the instrument tendered and enclosed herewith, private bonded promissory note number 7404, hereinafter instrument, and affiant believes that no such evidence exists. There is no evidence that the instrument is not sufficient to set off, settle, and discharge any and all alleged outstanding obligations, duties, and or liabilities for the defendants, and affiant believes that no such evidence exists. And then, of course, finish that up with my commercial oath and verification, again, reaffirming, reestablishing the jurisdiction and the level of unlimited liability under which this particular process and contract is being undertaken.
Notice that you undertook it for 2 other parties.
No, actually 3.
And which other 3 are those?
Well, there's this one character named Brandon A. Adams, another character named Alex H. Adams, and then yet another character named Garrett R. Adams. All 3, I have a paramount security interest over everything. You should see the security agreements with those 3 parties.
So if you're asked or requested to produce those, you have them available, do you not?
They are available. Would I produce them? Only if private contract bound me to, because those particular instruments, the production of such, would prejudice my paramount security interest.
What if the judge asked to see him in chambers?
If he has to see him in chambers, I would allow him to examine them, but I would not give up possession of them, because I've had judges take off with my private security agreement.
When you say that, what do you mean? You'd be in the office and you keep a hand on it and he get a look at it, or you turn the pages for him?
Yeah, I'd turn the pages for him.
Because they've actually taken off with your document?
They've actually taken off with private contracts of mine. And remember I told you about the court case where they conspired on a way to get me out of there because I was just playing games with them? That was one of the cases. And I even expressly said, you can take it and make copies of it, but I want that back. That is an original. They go, yeah. Never got it back. And I made requests for it, too. They go, sorry, it's the judge has it. Well, I go, well, go get it from him. He was supposed to just make copies and give it back to me. Nope, sorry, can't do that. And that private contract was very significant in giving me standing and being there. And no longer being the holder in due course of that private contract, I no longer had the rights, interests, and titles associated with being the holder in due course of that contract.
To have done that correctly, then you would have had to have just...
I should have just brought a freaking copy. Instead, I only had the original on me.
And perhaps use what's termed a copy certification by document custodian to verify and validate said instrument.
Exactly.
All right.
Be careful with your originals.
Brandon, I think I remember what I was going to ask you. 2 quick things. Jack keeps referring to a timely response. How quickly did you respond to their complaint? Was it just 3 days or less than 3 days? Or did you give yourself 30 days?
I'll be able to tell by the date. Theirs was dated the 15th. I received it on the 16th, but one of them was not received till this day, right? The third one? I was actually waiting for the third one before this went out. And because I was really within the 72 hours, I had no problem just sending it on the 19th. However, if I'd have had to wait a couple more days for that third instrument, I would have just nunc-pro-tunked it.
So if you couldn't get...
People here, Brandon, don't understand fully nunc-pro-tunc. If you were going to nunc-pro-tunc that document, what would you do?
I would just write up here on date, where I have March 19th, 2010. I would put whatever date I wanted it to be. Let's say March 17th, 2010, and then in parentheses, after the date, I would put nunc-pro-tunc, and I would italicize it.
But you'd put it in parentheses, the nunc-pro-tunc?
Yep.
But they can't. Thought they couldn't see that.
They don't need to see it. They just need to see the date, don't they?
So would you say that if you go over the 72 hours, you need more than 72 hours, you should always non-pro-tunc?
If you need to be within the 72 hours and you're not within the 72 hours, nunc-pro-tunc it.
Well, how do you know you needed to be within the 72 hours?
I don't need to be anything.
Okay.
I just chose to be.
All right. And lastly, Brandon, I thought some people would recommend when you sign your name again, you put the dash in between your first and middle name and then the colon.
Don't even get me started.
Okay.
Do you know why that even is? Why people do that?
I thought it had to do something with the language, the quantum language, or no?
Yeah. So if I'm going to put the entire document in adverb, verb, fiction and just put my name in quantum, what kind of retard do I look like? Okay. That, you're going to
Don't get me started.
You're going to make your whole claim in fiction and put your name in fact. That just makes you look like an idiot. So yeah, if I'd have done this whole process in quantum, then I would, of course, all the names would be in quantum. But the fact is, the whole thing's adverb, verb, fiction for the most part. Now, I do pay very close attention to how I write things such that they are, for the most part, quantified. And I'll show you an example right. I know I have it in here somewhere. Or right here. The instrument is, there's my verb. I didn't start with the preposition, but if the being an article followed by a noun, that's pretty good indication that the instrument is a noun because there's a preposition before it and no other modifiers. Okay, a modifier would be like if I said the bitchin' instrument or the really cool instrument or the, something like that. So the instrument is. Now here I am. Present, being, tendered, in good faith, for the set off and or discharge of any and all. See, here's my preposition, article, conjunction, preposition, noun. Or actually, this is this actually modifies this. So I get into a little bit of fiction here by saying alleged obligations, right? But if I didn't use this modifier, they would just be obligations. I want to make distinction. Now, to properly have this in quantum, I would hyphenate alleged obligations. And that would now be a compound noun, alleged obligations. Then it would also be alleged hyphen duties or alleged hyphen liabilities. Attributed, but that would also have to change here because now I'm doing adverb, verb. Now, these are fictions anyway, so it doesn't really matter. Thereby protecting and preserving all my rights, preposition, article. So see, the important things like rights, I make sure I put them preposition, article, noun. Noun, noun, because they're conjunctions and remedies. So those have all been made into a noun. Rights, titles, interests, and remedies.
And Brandon,
regarding any, what?
You use in my because you're actually the secured party.
Normally, this document's being executed
right.
as the executive trustee, the paramount security interest.
Normally, a lot of documents would be written in third person.
In reality, this one should be too. It should have been defined at the top that and given the executive trustee some kind of designation, and so it would be preserving all the executive trustees or paramount security interest holder or secured party creditors' rights, titles, interests, and remedies. You know what I mean? So I do, and actually when you get to my notice of default and things like that, like the notice of default we went over earlier, that's got a lot of quantum. I've actually deliberately gone through and I'm slowly converting as much of my processes over to quantum as I can so that there's as many nouns and as little fiction, adverb, verb fiction in it as possible. But dude, it's a process. It takes a while to quantify your language, just because it doesn't come as naturally as the fictional way we speak. Go ahead.
Okay, the instrument that you were speaking about tendering, that's to set off the charges?
That's to set off any alleged obligations, duties, or liabilities.
Okay, so did you have an amount there, or you just... How did you come out?
No, I did have an amount on the instrument.
So how did you come up with that?
They
that
had an amount in the complaint of damages.
Okay,
I
gotcha.
took that amount, hold on. I took that amount, multiplied it by the number of defendants, and then added an extra percentage onto that. So if they're saying, yeah, they've created $10 million in liability. Well, there's 3 defendants. So I said, okay, 10 times 3 is 30 million. Then I'm going to throw some on top of that in case there's interest, penalties, or fees. You see? So it was like a $50 million promissory note. Okay? Any other questions?
Yes. I noticed, and I'm very new to this, but I see a lot of times you're using the year of our Lord by something of God. That shows up quite a bit in your
You're talking about the
salutation
commercial
kind of.
affidavit,
Yeah.
the commercial affidavit, oath, and verification.
Can
I,
you just-
Brandon Alexander Adams, secure party creditor, under my unlimited liability and commercial oath, proceeding in good faith, being of sound mind, having firsthand knowledge, affirm, state, and declare that the facts contained herein are true, correct, complete, and not misleading under penalty of international commercial law, so help me God.
He's talking about in the year of our Lord.
Well, that too.
Yeah, this one doesn't actually have the in the year of my Lord, year of our Lord thing.
I just want to know why that's in there like that. I don't understand.
As opposed to a regular date is what he's asking. Why not just June 20th instead?
Oh,
in
why
the
not?
Year?
Why do I state
Why
the
do
date
you
like
say,
that?
so help me God? Why do you say
In the year,
of
in the
Lord?
21st, in the year of our Lord, and the instead of just June 21st,
If I was going to use that in my contract, I'd want to know why I'm using that, and that's my question.
For me, the reason why I say, why I use that date method is because date is like setting a jurisdiction as well. Okay? The calendar, the way it's used, and the way you write out dates actually symbolizes jurisdiction. Okay? Like there's actually a military way of of writing the date, right? Right. And by using writing out the 7th day of the 9th month, because even the names of the months designate a jurisdiction. Okay? In the year of our Lord, because I'm not saying, what is 2010? You know what I mean? So in reality, and you guys haven't even seen some of my other really private documents where I don't even use the dating system, that dating system. I use a dating system that's over 6,000 years old. Okay? So there's purposes behind why I do it, and it makes sense to me. If it doesn't make sense to you, critical thinking, change it. Make it say something else. This, for me, is significant because, for one, I only have allegiance to the Creator. I have no allegiance to the United States. I have no allegiance to the California Republic. I have no allegiance to any fiction. My only allegiance is to the Creator. So that's why that's the last word in there. Yeah. So and that's one thing that's kind of distinguishes me from all the other patriots out there. They want to have some kind of allegiance to the Republic, America, the California Republic, the Constitution. My only allegiance and the only law I recognize is that of the Creator. And as far as I'm concerned, that's the only law that I'm under. That's why my allegiance lies. That's why I have the power to contract with anyone. I can go contract with Spain if I wanted to. I can contract with anybody. I can go contract with Martians. Nobody can control who I can contract with because the only authority over me is the Creator. So, and a man who, and another reason why it's so important for you to truly understand the divinity of yourself is that a man who does not recognize his true divinity is nothing more than an animal. And if you're nothing more than an animal, your word has no meaning. Your word isn't your bond because you don't see there being any higher authority than that of yourself. Now, I recognize that the highest authority works through me. So I believe that God is in me and works through me. And that being the ultimate authority. The ultimate authority lives in me. But if I didn't recognize that it came from outside of me, then I would be nothing more than an animal. And therefore, what use would an oath be? You know, if you see nothing greater than that outside than yourself, then what is an oath? An oath is meaningless to a man like that. You know, there's only, as far as I know, one requirement to be a Freemason. You must recognize that there's a power greater than yourself. Doesn't matter what religion you believe in. But you must recognize that there is a higher law. Because in Masonry, all books of law, all religious texts of law are seen as sacred volumes of law. You can take your oaths on a Quran. You could take your oaths on the Old Testament. You can take your oaths on the New Testament. It doesn't matter. The Bhagavad Gita, you could take them on whatever volume of law you choose. You just must recognize that there is something greater. In order for you to be a man of your word and of worthy standing, you must be a man who recognizes that power outside of yourself.
You know, you need to very strongly consider the humanist credo. And it's thus: before man can be enslaved, his state of mind must be reduced from spirituality to carnality. He must learn to think of himself as basically an animal with no spiritual purpose. Once man is freed from his obligation to God, the way is cleared for his ultimate obedience to the communist state as his master. Scary stuff. They know exactly what they're doing. They give you a warning all along the way. Do you have eyes that can see and ears that can hear?
I noticed under your name you have all rights reserved, and if you were going to do this document over again, would you include that all rights reserved? You said.
Yeah, I don't see a problem with
because
that.
I was under the impression that that might not be a good thing to do unless you had something to do with performance. If you.
Oh well, I'm promising to perform.
So when you are promising to perform, it is okay to put all rights reserved.
That's what 1308 says, that you reserve all rights, but a right is a remedy. But the only way you can reserve your remedy is offer to perform. This is a conditional acceptance offering to perform. This is an affidavit in support.
Yeah, that's really what I'm saying. All remedies are reserved because I'm promising to perform.
Because you're going to perform.
Yeah.
Now,
I don't quote, you notice I don't have UCC 1-3, because again, the way I see the UCC, it's the codification of universal law. Those self-evident truths that make it possible for us to enter into contracts. I recognize that. So I'm not leaning on the code.
Right.
You know, whereas those who quote the code, well, you're kind of already putting yourself into some kind of jurisdiction.
Under the code.
Right? You're saying, I'm under this law. I told you, I'm not under any law but the highest. The Most High is the only thing I have an allegiance to.
My other question is in regard to when you were talking about bringing the documents to the judge and turning the page for him and never putting that document in his hands. What about keeping all originals in your possession and just submitting certified copies of those originals?
I could submit a certified copy.
That's what I think.
But at the same time, like I said, there's information contained in those particular documents that we were discussing that I would never want to leave even my sight. Okay, so if he wanted to examine it, I would bring him a certified copy, allow him to examine it, and then take possession of it. Because there is no need or purpose for him to hold that document. Because all he needs in chambers is knowledge of the contract.
The rules of evidence are that you can produce a copy. The only time you have to produce the original is if there is an allegation as to the unauthority of the signature thereon. And so if the judge were to see a copy and say, well, I don't believe that this signature is authentic, then you would have to produce the original. But unless they challenge the authenticity of the signature, you're perfectly okay producing a copy.
Commonly called, or more termed, prima facie evidence. And I would encourage all of you to look up prima facie evidence for an interesting definition, so we'll talk about it tomorrow.
Actually, there's a third, the significance of third-party records as prima facie evidence in the UCC Section 1, which I really recommend you read as well, because, again, that's right in line with why we create the records that we create. So actually, y'all want some homework for tonight? Just browse those couple sections that we've talked about in Title 1 or in Article 1 of the UCC. It'll be real easy to find. Just go right to the table of contents of Article 1, and you'll see all the subheadings. And you'll see on there third-party records, prima facie evidence. You'll see on there, what are some of the other ones we discussed today? Good faith. Definitions. The definitions. There were a couple other ones that I had mentioned today. Yeah, just go through all the subheadings in Article 1. Just Article 1. I mean, literally, just going through all the subheadings, which is like a table of contents for Article 1, just by reading those, which will take you all of 60 seconds, you'll see, oh, whoa, I want to read that one. Oh, that one seems interesting. Because you'll see right in there, in the title of it, you'll pick up on the significance of it. Yeah. All righty, any other questions? Sweet. All righty. We will adjourn for the evening.